The March 19th, 2026 Planning and Land Development Regulation Commission public hearing is now called to order. If I could have you all to please, please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Catch up. If we could have roll call, please.
Good morning, members. Member Arison?
Present.
Member Craig? Member Shelley?
Here.
Member Bush?
Here.
Member Sixma?
Here.
Acting Chair Sixma? Oh, sorry.
Hey, get on my
Costa?
Hey, gladly give it up. I'm here.
And Chair Mills is absent.
All right, before we get started, yes, ma'am. Oh, yes. Oh, will you please silence your phones and any audible devices you might have during the meeting? Thank you. Before we get started, we need to have a nomination and a vote on a vice chair. Anyone?
I nominate Member Bush.
Do we second?
Yeah, I'll second that one.
Do we second? All in favor? Aye. All opposed? Ayes have it. You want to slide on over?
Slide on over, girl.
Do I need to? I'm all plugged in over
Okay, well,
here.
then stay right where you're at. You're good.
Yeah.
I'll
Not that I don't want
I'll
to,
pass the
but-
gavel your direction. No worries. We have any minutes to approve on this one? I don't believe so.
No, sir.
No. So then let's go right into the, legal comments by Mr. Storia.
Sure. Thank you, Mr. Chair Pro Tempore, or Acting Chair. This is for members of the public and for applicants that decisions by this body on cases which rezone real property from one classification to another pursuant to the zoning ordinance are recommendations only to the County Council and do not constitute a final hearing. So new evidence may be introduced at the County Council public hearing. However, decisions on variances and special exceptions made by this body constitute final action, subject to an appeal to the County Council. And what this means is that no new evidence may be presented at the time of the County Council public hearing on the appeal. An aggrieved party that appeals such a decision is confined to the record made before this body. Hearings by this body on rezonings, special exceptions, and variances are quasi-judicial in nature, meaning that this body is acting more like a court and must take into account all oral, written, or demonstrative evidence presented. Their decisions on these cases must be based on competent substantial evidence in the record, and competent substantial evidence has been defined as that evidence a reasonable mind would accept to support a conclusion. Thank you, Mr. Chair.
Yep, and before we get started, let me say that the public is invited to speak on any matters that come before us today. If you would, please fill out a form at the back of the room and hand it in before you come up to speak, and we'll call you up when it's your turn. With that, let's go into any ex parte communications, and we'll start to my immediate right.
None.
I have none.
None. None.
None.
And I have none as well. Before we get started with the old unfinished business, there is one item I want to put to make a motion, or a vote, I should say. CPA 25006 and PUD 25005 have requested to be moved to the end of the agenda. So we need a motion for that to rearrange it. Can I get a motion on that, please?
I'll move that we move CPA 25-006 and PUD 25-005 to the end of the agenda.
Second.
Okay, we have a motion by Ms. Bush on that motion and a second by Ms. Shelley. All those in favor say aye.
Aye.
Any opposed? All right, then we'll move on right into old business. You would please read V 26009.
Yes, sir. V 26009, variances to the minimum yard requirements, yard and accessory structure requirements on urban single-family residential R3 zoned property.
All right, and this is Laura Costa. No relation, by the way.
Good morning, Board.
Good morning.
We have a variance application for a vacant parcel located at 1177 John Anderson Drive. We have the applicant is requesting 3 variances, one for a proposed 2-story home, and 2 for an in-ground proposed swimming pool. Variance 1 would reduce the north front yard from 30 feet to 25 feet for the proposed 2-story home. Variance 2 would allow the proposed swimming pool within the front yard setback, and variance 3 would allow a reduction of the front yard from 30 feet to 29 feet for the proposed pool. The property is a vacant corner lot, single-family urban residential zoning R3, and urban low-intensity future land use. The parcel was created in its current configuration by a subdivision exemption lot combination and lot line adjustment with 1175 John Anderson to the south in June of 2021. The approval was made as the property as a standalone conforming corner parcel, R3 zoning classification, which requires a minimum lot size of 10,000 square feet and minimum width of 85 feet. The subject parcel has an area of 10,800 square feet and a lot width of 175 feet on Brooks Drive. As a corner lot, it's subject to 2 front yards of 30 feet along the north and west lines. If a new R3 corner lot was created today, it would be required to be 15% larger than the minimum requirement pursuant to 72-612B1 in order to accommodate for that second front yard. FEMA flood insurance maps have the subject property mostly within flood zone X, and the northwestern corner of the property is the 0.2% chance annual flood hazard area. The proposed locations of the single-family residence and in-ground pool are outside of the flood zone area. During discussions with the applicant regarding the alternative safety features for the pool, we noted options such as a screen enclosure or a 6-foot fence would also require variance and could be incorporated into this request. However, the applicant was firm in his preference. He's going to put a 4-foot fence within the front yard as a safety feature, which would not require variance. A 4-foot fence is code for a swimming pool to meet the minimum height, safety height. Environmental permitting reviewed the application and had an objection to this project. Staff recommendation is to deny variances 1, 2, and 3. Should PLDRC find the applicants have provided competent substantial evidence for approval, there are 2 conditions provided for them to consider.
Any questions for staff? Troy Kent. Can we change those names, please?
Can you tell me what the jurisdiction is in the property map? Sorry, I'm trying to pull it up real quick. The property location map.
The jurisdiction is...
Yeah, it's all pink right there. So do you know what jurisdiction that is representing in the map?
that would be...
Yep, that's the city of Ormond Beach.
Ormond Beach? Okay. That's all. Okay.
Any other questions for staff? No? All right, thank you.
Okay, thank you.
Is the applicant present? Come on up, please. If you would please state your name and address for the record.
Current address.
Our current address is 316 Bucknell Drive, Daytona Beach, Florida. We hope to live at the 1177 John Anderson Drive.
And your names, I didn't catch the names.
Adam Marcus.
Sarah Gummy Marcus.
Okay. You've heard staff's report. Would you like to add to that?
She did a great job explaining the project and the request. I wanted to thank Laura for all of her hard work and the hours that she's put into this, along with myself and my wife. And thank you all for taking the time to review this today. We're asking for a very modest variance to the existing setback requirements, only a few feet. It will adhere to, the standard of the neighborhood, and we think it's reasonable and looks appropriate for what will be there in the future.
Do we have any questions for the applicants? No questions at this time? All right, thank you.
Thank you.
You may sit down. Do we have any public participation for this case?
No, sir.
All right, that being said, let's close the floor for public participation and open the floor for either discussion and or a motion.
I'll be glad to make a motion.
Please.
I move that case number V-26-009 be approved, subject to the staff conditions on page 24.
I'll second.
Second. Harrison. All right, so I have a motion by Ms. Shelley to approve case V-26-009 with the 2 staff recommend conditions, and a second by Mr. Harrison. All those in favor, signal by saying aye.
Aye.
Aye. All those opposed? Motion passes unanimously. Next case, please.
Yes, sir. Case number V-26-023, variances to the accessory structure requirements on urban single-family residential R4 zoned property.
And this is Mr. Chikula.
Yes, thank you. The applicant is requesting 4 after-the-fact variances to address the front yard encroachment of an existing 2.32 square foot and 8 foot high accessory structure and a 540 square foot detached garage and studio. The variances are: variance 1 is to allow the accessory structure within the east front yard. Variance 2 is to reduce the eastern front yard from 25 feet to 0 feet for the accessory structure. Variance 3 is to allow accessory structure detached garage studio within the eastern front yard. And then variance 4 is to reduce the eastern front yard from 25 feet to 24.83 feet for an accessory structure detached garage studio. The subject property is located approximately 900 feet from the intersection of Lake George Road and Peach Lane in Seville. This variance request is for a 12,689 square foot parcel developed with a single family residence and 2 accessory structures as mentioned before. The parcel was purchased by the current owner in 2004, and building permit records indicate that the principal structure and detached garage with the studio were permitted in 2006 with construction around 2008. The approved plan did not clearly depict the building setback from the easement line that is also on the front yard of the property, resulting in the garage being located within the front yard, creating a minor or de minimis encroachment. The second accessory structure, consisting of a wall with footers and electrical service used for lighting, was constructed approximately between December 2017 and April 2018 without permits, and is associated with an active code compliance case, which prompted the variance request. The property is zoned urban single-family residential R4 and meets the lot size and the width requirements. However, both accessory structures are located within the 25-foot front yard setback. The site is located within the flood zone AE. The original building permit included FEMA certification at the elevation of 8 feet. 1 foot above the base flood elevation. Environmental permitting has reviewed the request and has no objection, however, provided that the project remains in compliance. In addition, there were 3 letters of opposition that were submitted to you for your review. And then staff recommends denial for variance requests 1 and 2, as they do not meet 3 of the 5 criteria for approval. And then staff recommends approval for variance requests 3 and 4, as it meets all 5 of the criteria. Should PLDRC find the applicant has provided competent and substantial evidence for approval, the conditions are provided to you below.
Any questions for staff? I do have one. So there's existing items that we're trying to get variance for, and then future to be built items as well, correct? We have a combination of the two?
No, the 2 structures have already been built.
Are existing, okay.
Yeah, the garage/studio was built with permits in the past,
Okay.
but at the wrong setback.
Gotcha. All right, thank you. There's no other further questions for staff. We'll call the applicant up.
Thank you.
Thank you. If the applicant's present, please come forward. State your name and address for the record. Good morning, sir.
Good morning. My name is James Hannes. 1668 Lake George Road is my residence.
Okay.
What I'd like to respond to is that My response is to acknowledge that I sent out 7 certification letters sent to the adjacent property owners for their information and feedback. The result provided a total of 5 out of the 7, or 73% of the property, 73% of the property owners that did not deny the variances.
Did you present those letters to
we
us?
have copies?
Do we have copies of that?
Yes, I do have a copy of it. So the one couple in the house is part of that 3. So each house, I suspect, is one individual or one vote. Otherwise, you'd have all the partners or all the owners of each of the house doing 2 of these.
Okay, we'll check with staff here in a minute.
So there's some that are married and some are not.
Okay. Anything else you'd like to add? Do you have anything else to add? Ms. Stucker will take this. There you go.
That's just one letter.
Yeah, that's what it looks like.
And I'll say the planning and zoning has been extremely outrageous in terms of the working, and the quality of work and their findings is acceptable.
Okay. Hang on, sir. Any questions for the applicant? Sir, come right back up. Any questions for the applicant? No? You may sit down then. Do we have any members of the public that want to speak on this?
No, sir.
No? Do you have those letters by chance? Oh, you do? Did you fill out a form afterwards, sir? Please come on up.
I did it ahead of time.
You have filled one out?
You gave her a form?
Filled out a form?
I was one of the ones that sent an email in.
No, I understand that. When you're done talking, there's a form in the back if you don't mind filling, just for the record.
Oh,
fill it
okay.
out and
Yeah,
turn it in.
fine. No problem.
State your name and address, please.
Robert Trimmer, 1693 Lake George Road.
Okay, go ahead, sir.
And I'm completely opposed. I don't mind if he keeps his garage, but I think he needs to has to be able to remove the wall, because that's in complete violation of any codes for the county, a setback rule. He's blatantly been somebody that has thumbed his nose at county codes and done things on this property that repeatedly that he's gotten in trouble for putting in doors without permits and putting in windows without permits, doing roof projects without permits. Yet he goes around and tells everybody else in the community what they're allowed to do and what they're not allowed to do. He thinks he's code enforcement somehow. Personally, it would be very erroneous in my opinion that the county would allow him to keep the wall, simply for the fact that you'd just be thumbing your nose at everybody else that does everything by the book, by the code. I put windows and doors in my house there and got the permits properly and everything to do all that because I worked in the industry and I know what is required. He has sliding glass doors on the second and third floor that they allowed him to keep that he put in without a permit, and that was established, that go to nowhere. There's no balcony, there's no protection to stop them. They allowed him to screw them shut, which should have never been allowed. If he'd have got the proper permit to do it to begin with, they'd have never allowed him to install those. Why he was allowed to get away with that after the fact is beyond me. I don't understand that because I worked in that industry and that is a big no-no. Anybody could pull those screws out if he was to sell that house later on. Small child fall out to his death, second, third floor. Yet he still has those doors. He should have had to replace those, in my opinion. And that's just one of the reasons that I feel he should not be allowed to keep the wall. Simply for the fact that he should be held accountable for the things that he does without the permit that he expects everybody else to do in that community of Seville. So.
Okay. Any questions for the speaker? No. Thank you, sir. Any other public participation? Then we're going to close the floor for public comment and have discussions up here or a motion.
Chair, if I may, sir,
you may.
would you mind coming up to the dais to fill out that form, please? The gentleman that just spoke?
Yep. Yes,
Thank
sir.
you.
Thank you. All right, so any panel discussion and or motion, please, on this case? Yes, please go ahead.
Yeah, I'd like to move that we separate this to a vote with variance 1 and 2 and variance 3 and 4.
Separate the two, so you want to make two separate motions? All right, go ahead.
Do I need to make it?
Yep, make your motion.
Make two motions.
I'd like to move that we separate the variances into two different votes with variance 1 and 2 together and variance 3 and 4 together.
Need a second on that?
Yeah, I'll second that one.
All right, so we have a motion on the floor on case V 26-0023 to take separate votes on variance 1 and 2 as one, and a separate vote on variance 3 and 4 as another. All in favor, signal up by saying aye.
Aye.
Aye. All opposed? All right, moving on. So let's take variance 1 and 2. Discussion or a motion?
I'm ready to make a motion. I just have a question. In making a motion, do I have to make it in the affirmative here or no?
Yes. So in the
That's what I thought.
affirmative, it would, yes. When I say in the affirmative,
That I recommend to deny?
yes, that would be an
Thank you,
affirmative
just
motion.
confirming. I'll make a motion that case number V-26-023, I recommend denial of variance 1 and variance 2, subject to just variance 1 and variance 2.
So denial on variance 1 and 2?
Yes, sir.
Do I have a second?
Second.
We have a first and a second on the motions. So we have a motion by Ms. Shelley and a second by Ms. Craig to deny variances 1 and 2. All those in favor signal by saying aye.
Aye.
All those opposed? Motion passes unanimously. And then moving on to variance 3 and 4.
I recommend on case number V-26,
Let me stop you for a second. So I just want to make sure that's a motion for denial on variance 1 and 2.
correct.
Okay, all right, moving on.
I recommend on case V-26-023, recommend variance 3 and variance 4 be approved, subject to 4 staff conditions.
Second, please.
Mr. Chair, just to clarify, it would just be 3 staff conditions. It would be condition 2, 3, and 4.
Oh, yes, I'm sorry. 2, 3, and 4. Second.
Second by Ms. Bush. All right, so we have a motion on the floor on case V-26-023 on variances 3 and variance 4 to approve with staff recommended conditions number 2, 3, and 4. And a motion by Ms. Shelley and a second by Ms. Bush. Any discussion on the motion? All those in favor signal by saying aye.
Aye.
I'm an aye as well. All those opposed? That one passes unanimously, 7-0. Okay, that concludes. Thank you. And we are moving on to, now we're at new business. First item is V-26-025, and it is Mrs. Tucker. Ms. Tucker. I'm sorry, read that into
Yes,
the
sir.
record, please. I'm getting ahead of myself.
I was waiting. Case number V-26-025, variances to the accessory structure requirements on urban single-family residential R4 zoned property.
Ms. Tucker?
Good morning, members. Today before you, we have a case where the applicant is requesting 2 variances to reduce the minimum waterfront yard setback for an in-ground pool and screen enclosure in the urban single-family residential R4 zoning. The subject property is located on the south side of Azalea Road and is non-conforming to the R4 zoning classification, as the property is only 6,961 square feet in area and has a lot width of 57.24 feet. The R4 zoning classification does require a minimum lot area of 75,000 square feet and a frontage of 75 feet. The parcel does have a vested status and is eligible for building permits, and in May of 2015, the property did receive a variance to separate from the parcel to the west. The applicant purchased the property in June of 2025, and the property was previously developed with a 1,541 square foot single-family residence that was developed in October of 24 by the previous property owner and up to the 25-foot waterfront setback line. In November of 25, the applicants applied for building permits for the pool and screen enclosure and were notified that they were encroaching in the waterfront setback. The proposed pool will be 13 feet from the property line, and the screen enclosure will be 10 feet. According to the applicant's written petition, the pool is to be used for physical therapy. Environmental permitting did review the request and didn't have any objections. However, they did identify that the site is in the Indian River Lagoon Surface Water Improvements and Management Overlay. The applicant does already have a current wetland alteration permit in-house that is associated with the building permit. Staff did receive one letter of support and one letter of opposition that was presented to you today for your review. Staff recommends denial for the variance request as it fails to meet criteria 1 through 4 for granting a variance. If the PLDRC does find that the applicant has provided competent substantial evidence to support approval, staff has provided 3 conditions for consideration. I'm available for any questions.
Any questions for staff? I have one. The letters of opposition, are they in this packet?
Yes, sir. It was the highlighted form. We received it on March 9th. It would have been in the stack of papers you received. I do have one extra copy if you'd like
The
it.
ones you handed out today or in our,
The ones from this morning.
this morning? Okay.
Yes, sir.
Give me 1 second to look those up, please.
I believe it should be either page 2 or 3 in the packet.
25-6 CPA. Everybody find those?
Yes.
All right,
Just
great.
starting to read.
So no questions for staff then?
I have a
You do have one?
I have a comment.
Go ahead, please,
so
Ms. Bush.
I just wanted to say thank you for labeling the property location map. So, it helps.
Make it simple, yeah. Thank you. Any other questions?
I did have one comment.
Please go ahead.
I don't know how relevant it is, but when Ms. Tucker was reading, she said that the lot was 75,000 square feet, and it was 7,500 just for...
No, ma'am. The R4 requires a minimum of 7,500 square feet, and this lot is just under 7,000.
And all I meant to say was, you misspoke and said 75,000 instead of 7,500.
Thank you. Those zeros do get a little tricky sometimes.
Any other questions or comments? No? All right, moving on. Is the applicant present? Please come forward, state your name and address for the record.
My name's Daryl Corbett. My address is 160 Azalea Road, Edgewater, Florida, 32141.
Okay, you've heard staff's presentation.
Yes, sir.
Would you like to add to that?
I do have, there was 4 letters actually of approval and recommendation for this being done by my immediate neighbors around me. I did get, as was pointed out by Kelly earlier to me, that I wasn't aware of. There was one neighbor that, for lack of better terms, has been a problem since we moved in anyway, so I wasn't expecting anything nice from them. But this pool is very small relatively. There are 118 houses located on those canals. Out of those, 49 of those have pools. And 3 are being built right now, or actually 2 are being built. One just got completed this year. So getting a pool on that property or on those canals is not unusual. And if you look at those, all the ones that exist now are closer than the 10-foot setback. Most of them, about 70%, actually sit up on the water itself. They can overlook the canal standing on their pool deck. I'm asking for a very small pool, 9 by 12. It started out 9 by 9 because of my disability. The pool company recommended I go longer, so I had stairs going down into the spa, and I wasn't stepping down a giant step into the spa. That's what this is for. It's not a large. If you look at the size of the pool that's being built in comparison to the house, to the property, and other pools around mine, this is very small and it's looking for a health benefit.
Okay. Any questions for the applicant? Ms. Shelley?
And I wanted to make a comment, just to reiterate that the home that is there, I was looking, was by the previous owner.
No, ma'am.
Built it
that
in
was a
25?
mistake. I
Oh, you
purchased the
built it.
property
Okay.
and the end of, I believe it's 2022, and we built the house.
So you built the house?
Yes,
Okay.
ma'am.
Thank you. Thank you for clarifying.
And I do have, anybody else? I do have one question. You said you had multiple letters of support.
Yes, sir.
Did you turn those in?
Yes, sir. They were emailed over to Kelly. I've got copies of those if you need those.
I have the one that was in our pack, one pro, one con.
And when I looked through my email, I had only had the one letter that I'd received from Mr. Corbin.
If you have them and you want to turn those in, that would be part of the record today.
Yes, sir. To Kelly?
Yep. We'll pass those along. Do you have anything else you want to add?
No, sir.
Okay, thank you. You can have a seat. Do we have any speakers for this case?
No, sir.
No? In that case, we'll close the floor for public participation and open it up for discussion and or a motion.
I'll make a motion on this.
Go ahead.
Case B26025. I'll make a motion for approval with the 3 staff conditions.
Second.
So I have a motion on case V26-025 by Mr. Sixma and a second by Ms. Shelley. Any discussion on the motion? All those in favor signal by saying aye. Aye. Any opposed? Passes, V26-025 passes unanimously. Okay. Next case, Ms. Shelley.
Yes.
Thank you.
Case number V-26-028, variances to the accessory structure requirements on urban single-family residential R4 zoned property.
All right, and this is Laura Costa again. Still no relationship.
Still? Gosh, I'm so sorry. She keeps saying no.
Good morning.
Morning.
The applicants are requesting 2 variances for a proposed 440 square foot carport. Variance 1 is to allow a proposed accessory structure located within the front yard, and variance 2 is to reduce the south front yard from 25 feet to 14 feet. Subject parcel was developed with a 2,278 square foot single-family residence, which was constructed in 2024 by Dickerson Construction. Applicant purchased the property in November 2024 and added a screen room constructed May of 2025, and then has submitted a building permit for the carport as well in December of 2025. The carport is going to be facing Beasley Drive and is intended to provide shade and protection from inclement weather and to store his vehicles. Please note that the home was built with a 2-car garage. Per FEMA flood maps, the subject property is wholly located within flood zone X. Environmental permitting reviewed the variance request and stated they had no objection to the carport as long as they follow all the, comply with the environmental regulations. Staff's recommendation is to deny variances 1 and 2 should PLDRC find that the applicants have provided competent and substantial evidence for approval. The 2 conditions have been provided for your consideration. Staff has received 3 letters of support from adjacent owners.
Okay. Any questions for staff? Bush.
Thank you. First, thank you again for labeling the property location map with the jurisdiction. You have no idea how helpful that is for me, so thank you.
It is helpful.
I wanted to ask, are there any, I did a quick Google Maps aerial search. I didn't go drive around the community, but do you know if there are any other front yard carports in this community?
There is one unpermitted one across the street.
Okay.
All righty then.
Thank you.
And we'll see them next month.
Yeah.
I haven't heard from them, so.
Okay.
Yet.
Yet.
Thank you.
You're welcome.
Any other questions for staff? All right, thank you. Is the applicant present? Please come up, state your name and address for the record.
My name is Dana Taylor. I live at 1683 Beasley Drive.
You heard staff's report. Do you have anything you'd like to add?
Yeah, I wrote it out if I can read it.
Mm-hmm.
The criteria analysis of fact. Number I is no special conditions are warranted for an accessory in the front yard. They reference the pickup truck that I have is too large, too long to fit in the garage. And when we try to fit 2 cars in there when we moved in last year, you couldn't open the doors to get out. The garage is quite small for a 2-car garage. Special, and number 2, special conditions and circumstances for actions of applicant is not planned to be a storage place, but to serve as a park, to park operational licensed vehicles, 3 of them. 2 vehicles for sun rays, 2 vehicles to protect vehicles from sun rays, normally protected by adequate garage space. And the covered workspaces also will serve as home improvement, things like that. You back the car out, you do something, you put the car back in. A literal interpretation derives the right applicant and reasonable use. The carport anchored to the existing driveway is the only in the front is the only location. Front yard is used for septic field. It was suggested I put it in there. It was also suggested that I put it in the rear, and the rear has a slope in it, and the slope and ease landscape is sloped, and they suggested a permit for the garage, I guess, to take stuff out of the garage and put it in there. We went through a 4-month permit to put a tough shed in the backyard, and it's very small. It was just for lawn stuff. The harmony in the neighborhood is very good. Before I started, when I first started this whole process, I was told by the people in the carport, they said, get your neighbors to write a letter and tell them that you're what you want to do. Get them to help you approve. I did. I started with the letters, and there's 3 of them, 3 or 4 that were attached with my packet, and I didn't know that it was when I started it. I went to about eight people down the street, and I had that form that I have in their letter, and I asked them to. I talked to them about what I wanted to do and why, and I did about 10 of them, and I didn't realize that I had to have one for just the people that touch the property. So I did those, and those are included except the one in the back, and I didn't know that I could bring the other ones in, because there was 28 people in the street I live on, the Beasley Drive, and I could have brought them in, but I didn't. So and the last thing on this is that I know that all of my neighbors don't have a problem with it. So.
Okay, and see if we have any questions. Ms. Shelley?
I just have a couple of questions, or one question, really. Will the roof of your carport be taller than the roof of your garage? Will it be?
No.
Oh, I was looking at the vehicle. Okay.
It's actually 9 feet. It's 9 feet from.
So it will come off from the garage at an even.
Just at the eave above the garage door.
Great, thank you. And this really has nothing to do with the applicant, but I was looking at the neighbor next door with all the cars in the front yard. So I think, anyway, just a comment.
Okay. Ms. Bush, you have a question or comment?
I do. Did you consider adding on to the principal structure and doing some kind of attached carport instead of a one that you would have to construct 6 feet away?
Well, I like the idea that it's away from the house. I don't know that if that I could probably have the carport people do it, but in the way I was trying to do it was I have a 3 feet. If you come out of the entrance of my house and you're coming out, and there's a 3 feet space. This was before we put the additional width of the apron I call it on the driveway. And so right where that apron starts is where it's a new it's wider.
Right.
And so that corner would have a stanchion going up in the corner that would hold the corner of the.
Yeah, I'm just trying to. My point was, is there a way that you could aesthetically design this to match more of the house and in harmony with the community, rather than just installing something that's prefab that?
It is black roof, black trim, and white, and it's a white house with black roof and trim.
Okay, thank you.
Mr. Erson.
My concern was, you wrote on here that the RV is going to be moved, but where?
Oh, I'm selling it.
Oh, okay.
Yeah, I have the plan. I had a plan to put the trailer next to the house on the other side by the front, and there, because there's a gate there and there's a fence. The problem is that's when I found out that the septic system was there. So I know I've either got to go put it in storage, which I did for a year, but I took it out of storage because I'm going to sell it if and when I get the carport. If I don't, I'll sell it. If I do, I'll think about it. But I can't. It won't fit under it. It'll only go. The inside of the carport is only 8 feet high.
Mm-hmm. Ms. Craig.
Thank you, sir. Of the 28 people, the neighbors that you sent letters to, were there any objections to this project?
Oh, no. And, no, it was. They were. It was a really an interesting way to meet your neighbors because we were there a year and we see people go by and and all that, but and being on a dead end street, we see the same people all the time. So, but when I talked to them, they were many of them told me to do it without a permit.
Maybe they're not sure about you.
That was the guy across the street with the illegal one.
That's the guy with all the cars in the yard.
I'm sorry, I should say that. They
That's
weren't
okay.
suggesting that I break the law, which I did. I had a permit for my tough shed, a permit for my screen room in the back, and even the guy who did my screen room, one of his guys said, you don't have to do that. You don't need that. I went and got the permit. They said, well, I got the permit. So I got through the permit process for this, and then suddenly I was stopped for something I didn't know anything about, and it was quite a surprise. And it's been a long journey to do this. So.
Okay, great. Thank you, sir. Any other further questions for the applicant? All right, you may sit down. Thank you. Do we have any public participation?
No, sir.
All right. With that, we will close the floor for public participation and bring this back to us for discussion and or a motion.
I'll be glad to make a motion.
Please do.
That we approve case number V-26-028, subject to the two staff conditions on page 5.
Second.
And okay, so I have a motion on case V26-028 from Ms. Shelley and a second from Mr. Erson. Ms. Bush, did you have another question before you move on?
No, just a comment.
Go ahead.
I just wanted to say that I'm going to be a no on this, just because I would love to see the structure tied more into the house, and I don't think it's in harmony with the neighborhood. I think that is going to be an issue that we're going to see later on down the road. So I just want to explain my vote and appreciate the opportunity. Thank you, Chairman.
Again, we have a motion by Ms. Shelley, a second by Mr. Erson. Any other comments? Okay, all those in favor signal by saying aye.
Aye.
All those opposed?
Aye.
So we have one in opposition. Is that 6-1? Is that right?
Yes, sir.
5 to 1.
5 to 1, sorry, 5 to 1. So this motion passes 5 to 1. Thank you. And the next case, Ms. Shelley, please.
Yes, sir. Case number CPA-25-006, small
Nope.
scale. Oops, did I
Hang
go
on.
to the wrong
Back
one?
up, yep.
I'm trying to move on too fast.
Yep, 2632.
Oh, I flipped that one right over. Case number 26-032, variances to the minimum yard requirements, maximum lot coverage, and maximum fence height on urban single-family residential R3 zoned property.
Good morning, Ms. Ray.
Good morning. So the applicant is requesting 10 variances to the minimum yard requirements, the maximum lot coverage, and maximum fence height for the existing residence, an approximately 2,661 square foot home addition, and a proposed 6-foot CMU privacy wall. There are 2 subject properties, parcel 1 that is 1774 John Anderson Drive, and parcel 2 that is 1776 John Anderson Drive. Parcel 1 is currently developed with a 1-story residence and a dock. This residence is proposed to be demolished. Parcel 2 is currently developed with a 2-story residence that was constructed in 1955, a swimming pool, and a dock. This residence is proposed to stay with the home addition added onto this one. The applicant is currently going through a lot combination of the 2 parcels to create one unified building site. The Halifax River is located along the western property lines of parcels 1 and 2, and along the southern property line is the Roberta Road extension. Because of this, the property will have 2 front yards, a waterfront yard, and 1 side yard. The properties are zoned urban single-family residential R3, which has a minimum lot area of 10,000 square feet. Individually, the 2 properties do not meet the minimum lot area. However, once they are combined to create one unified site, the lot will meet the minimum lot area requirement at approximately 11,090 square feet. The R3 zoning classification has a minimum front yard setback of 30 feet, side yard setback of 20 feet combined with a minimum of 8 feet on any one side, and a waterfront setback of 25 feet. Variances 1 and 2 are for the existing single-family residence. Variance 1 is to reduce the north side yard from 8 feet to 3.8 feet. Variance 2 is to reduce the east front yard from 30 feet to 5.2 feet. Variances 3 through 5 are for the proposed home addition. Variance 3 is to reduce the east front yard from 30 feet to 25.2 feet. Variance 4 is to reduce the south front yard from 30 feet to 10 feet. And variance 5 is to reduce the west waterfront yard from 25 feet to 15.75 feet. Variance 6 is to increase the maximum lot coverage from 35% to 46% for the existing residence and the proposed home addition. The fence height requirements are within section 72 to 82 of our zoning ordinance. For a fence placed within the waterfront yard, it shall not exceed 3 feet in height, except those with the opacity of 25% or less. Fences placed within the front yard shall not exceed 4 feet in height. Variances 7 through 10 are for the proposed 6-foot CMU privacy wall. Variance 7 is to increase the maximum fence height from 3 feet to 6 feet for 10 linear feet along the western boundary within the west waterfront yard, which is the orange cloud on the left-hand side. Variance 8 is to increase the maximum fence height from 3 feet to 6 feet for 25 linear feet along the southern boundary within the west waterfront yard, which is the, I think it's green, squiggles right next to it. Variance 9 is to increase the maximum fence height from 4 feet to 6 feet for 59.5 linear feet along the southern boundary within the south front yard, which is the purple. And then variance 10 is to increase the maximum fence height from 4 feet to 6 feet for 30 linear feet along the southern boundary within the east front yard. Staff recommends to approve variance requests 1 and 2 as the variances met all 5 criteria. Deny variance requests 3 through 6 as the variances failed to meet criteria 1 through 4. Deny variance requests 7 as the variance failed to meet all 5 criteria. Approve variance requests 8 and 9 as the variances met criteria 1, 2, and 5. And deny variance request 10 as the variance failed to meet all 5 criteria. Should the PLDRC find that the applicant has provided competent substantial evidence to support the approval of the variances, 7 conditions were provided for your consideration. I do also want to add that 2 letters of support were provided in the staff report package from the adjacent neighbors to the north. I'm available for questions.
Any questions for staff? Ms. Bush?
Yes, thank you. Do you know what the impervious surface ratio of the property is?
So the impervious, like as it currently
What
stands?
the proposed ISR is?
I do not.
They're asking for a variance to the lot coverage, so I would love to know what that impervious surface ratio is before.
Absolutely. I do not have that calculation on hand at the moment.
Okay.
I just know the lot coverage, which is what's under.
Right. Okay.
Any other questions for staff? I do have one quick one. This is not considered a corner lot by any means. It is.
Yes, sir. That the south, the Roberta Road extension that goes to the public pier, that is considered a right-of-way still.
Okay, so even though the
So it
road
is
is punched through, it's considered a right-of-way, so hence 2 front yards.
Yes, sir.
Okay. All right. If no other questions, then thank you. Well, the applicant's present. We'll call him up. Please state your name and address for the record.
My name is Chris Whitney. I live at 297 Leslie Lane in Lake Mary, Florida. I'm the architect for the project.
Okay.
First, I want to say thank you to Kristen and her team. We've had multiple meetings and conversations that have crafted this solution and provided an extensive amount of information. So she's been fantastic to work with. I'm happy with her support on a few of them. I stand to speak to support the ones that are declined. I also have an additional exhibit. As I was writing my narrative, I thought it might be easier to have one more picture. There's no new information. I don't know if I give it to you. And you can give it to him. You also received an extensive packet of additional sort of narrative, yes. And the term that we're using is hardship. As you look at this site, it's very oddly sat on the property. The house is not square to the street, and that's consistent for several lots, and that shows up in the exhibit. So we're using the term sort of hardship, something that we didn't create. What you're going to see in the exhibit that we give you is that our solution actually improves all those conditions of which we were denied for. When we remove the existing house, and you'll see that in the sketch, the red box is the old house that we're taking away. The black box is the proposed addition, and that little sort of white area in the black line is exterior space. It's both a summer kitchen on the first floor and there's a balcony on the second floor. So depending, it's not conditioned space that's actually crossing that. So I'm going to go one by one through the ones I took exemption to. On number 3, our front yard. As you notice, only a tiny corner of our addition actually fails that red line, and we are significantly behind on our front yard from the John Young. Number 4, the setback is, although it is called a corner lot, you can see that the house that we're taking down did not address the fact that it was a corner lot. Robert Road Extension really is a wooden pier. There's never going to be an extension of that road. So with all that being said, we are still improving that setback by 5 feet. So we are 5 feet farther away from the property line than it is today. So we have improved, again, that condition. Number 5, in the exhibit of the proposed construction, crossing setback of the exterior space the setback from the river, or the intercoastal as I call it, really doesn't hit the actual structure. It only hits our exterior spaces. So we think that we're certainly within family of that. Number 7 and number 10 relate to the height of the fence. Because that is sort of public access and there's lots of people going up and down that walk, Our homeowners are just hoping to get a little more privacy. They're building a brand new seawall. The seawall was deteriorated, so all that under separate permits under construction. And we have the environmentals and all those things that support that. So we're just looking for that extension of the wall to provide a little more privacy from that public access on that dock. So that's our response to the 10. I'm ready for any questions.
Any questions for the, yes, Ms. Bush?
You did not speak to variance 6, the increase in lot coverage, 35% to 46%. Would you like to speak on that?
I just jumped over it. Our coverage is consistent, and you'll see in the picker package with, if you look at the photography of the neighborhood, that's just sort of the way this neighborhood builds. And so, you know, the variety of pool surfaces and driveways, we think we're being consistent with the neighborhood.
Understood. Pools aren't a part of that lot coverage that I'm aware of.
And the way we calculate it, yes, that's
It
impervious
is?
area
Okay.
stuff. So
Can you inform me then, is the red box smaller square footage than what you're proposing?
the red box is the house that we're removing, and we are larger than that, but we are farther away from what I think the critical setbacks are.
I understand, but my question was, is it larger? And
Yes.
Yes, okay.
Yes, you can see that by the size of the gray box versus the red box.
I just wanted confirmation. Thank you.
Yes, ma'am.
And, but one more question. Do you know what the impervious surface ratio is on this lot?
I believe when we calculated those numbers for the 46, that was our impervious area. So that's,
No, your impervious area is way more than that. It includes all your pavers. It's anything that water can't percolate through is
I don't have
considered.
that number.
Ms. Bush, I can answer that question.
Oh,
From
thank
their
you.
original submittal, it's about 72%.
yeah, I thought we had those
From
numbers.
the original submittal?
Yes, when they provided their variance application, they calculated lot coverage to include the pavement, which we corrected them that it's only the roof structures.
Okay.
But the ISR is 72.2%.
72. Okay, thank you. That's helpful.
I knew we had the number somewhere.
Any other questions for the applicant? Anyone? No? All right, thank you.
Thank you so much for hearing us.
Do we have any public participation on this?
No, sir.
All right, we have 2 letters of support in the packet, and any supplemental emails or letters?
Not from what you additionally received yesterday or day before from Steve.
And if you would please, what we received yesterday or the day before, was there any opposition letters in that packet?
No, sir.
There was 1 or 2? Yeah, I'm having trouble finding it in my packet, that's why I'm asking.
No, there's no letters of opposition. There was only those 2 letters of support. The supplemental information that Steve sent, yes, that was just additional information from the applicant.
Okay, but there's no letters from neighbors?
No,
Okay,
sir.
Thank you. There's no other questions, or statements. We're gonna close the floor for public participation and open it for discussion and/or a motion.
I'll be glad to make a motion.
Please do.
Can I, real quick?
You may. Sorry, we have a couple comments. Go ahead, Emily.
Yeah, sorry. I just wanted to see if we could break up the variances again like we did with the first case.
What are you proposing?
Ooh, there's a lot of them. So I'm proposing to pull out variance 6. I do not feel comfortable approving that where it stands. I don't like where the ISR is, and so I want to. The rest of them I'm fine with.
You want to separate that as a separate vote?
Yes.
Variance 6?
Yes, please.
All right. Ms. Craig?
Thank you. Yeah, I'm also having a problem with variance 6. I think that the water runoff up in that area is a real issue, and I don't think that this is going to help matters any. The fence height along the southern boundary, I think I'm okay with it up to a certain point, but it seems like to take it 6 feet all the way out to the street practically is could pose a traffic problem. And yeah, I think those are my main objections to this. Yeah, I think that's it.
Any other comments? Waiting for the motion.
I'll be glad to make a motion that we approve case number V-26-032, variance 1, variance 2, variance 3, variance 4, variance 5, 7, 8, 9, and 10.
And we have a second on that.
Yes, she wanted to do that separately.
Yep. You want to go ahead and make that motion as well, and then we'll take them separately.
Sure. For V26-032, I move that we deny variance 6, increasing the lot coverage from 35 to 46%.
So we have a motion to deny variance 6.
I'll second him on that one.
Okay. Motion to deny variance 6 by Ms. Bush and second by 6. All right, let's go through this. So case V-26-032. The first motion is for variances 1, 2, 3, 4, 5.
I think legal was trying to hear.
No, it's fine. Yeah, so you're doing the first motion first, and you're
Yep.
going to vote on that first, and then you do the second motion by Ms. Bush.
I have Sigma as second in the first motion.
Yeah, we had a second.
Yeah. Yeah.
We,
Yes.
we did
We haven't
two
done roll
motions.
call yet.
We haven't done roll call yet, but we just
No, we haven't
did two
voted yet.
motions.
We just got the motions. I'm just rereading them back into the record. So let's start again. So case V-26-032. I have a motion on the floor by Ms. Shelley and a second by Mr. Sixma to approve variances 1, 2, 3, 4, 5, 7, 8, 9, and 10. And then we have a second motion on the floor from Ms. Bush with a second also by Mr. Sixma to deny variance number 6. Correct?
If I can ask you something real quick.
Yes.
If we don't include that in the first motion, will we needed a second motion to deny the number
Yes,
6?
yes, you would.
Separately, yeah.
So you have two motions. You will need to act on them separately.
Yep.
So the first motion you're going to vote on is a motion to approve 1, 2, 3, 4, 5, 7, 8, 9, 10.
Right.
Everything but
7, 8,
6.
9.
Yep.
Yeah,
Right.
everything
So
but
once
6.
that is done, either you approve or deny, then you move on to the second motion, which is just on whether or not you would want to deny variance number 6.
Yep, that's it.
All right.
And I want to, for the record, I'm guessing you were wanting to have the recommendations in there as well for your motion,
Yes.
Yes.
Ms. Shelley? So for the first one to approve all of those, it'd be 1, 2, 4, 5, 6, and 7. Those are the conditions.
Correct.
2, 4, 5, 6.
And I'll reread that before we vote. Mm-hmm. We're good? All right, so one more time. Case V-26-032. Motion on the floor by Ms. Shelley and a second by Mr. Sixma to approve variances 1, 2, 3, 4, 5. 1, 2, 3, 4, 5, 7, 8, 9, and 10 with the staff recommended conditions 1, 2, 4, 5, 6, and 7.
We're not doing 6 in the vote, in this first vote.
Correct. That's why I skipped number 3.
Oh,
Yep.
Okay.
Okay, that's on the that's on the recommendations. All those in favor signal by saying aye.
Aye.
Any opposed? All right, so the first motion passes. Now the second motion, again, case V-26-032, motion on the floor by Ms. Bush and a second by Mr. Sixma, and the motion is to deny variance number 6. And the condition number 3, staff recommended condition number 3. So this is a motion for denial.
There wouldn't be a condition if we're denying.
There is just one condition, right?
Well, we wouldn't be
We
putting
wouldn't
a
need it,
condition
right?
on the denial. 'cause
Okay.
it's a denial.
Just one, okay, just the variance number 6. All those in favor of the denial, say aye.
Aye.
All those opposed? Aye.
Aye.
So let's do that, a roll call, please.
I was just going to ask.
On the denial, so we're voting on the denial, please. Go ahead. All
Member
those in-
Arison?
Deny.
Member Craig?
Deny.
Member Shelley?
Approve.
Member Bush?
Deny.
Member Sixma?
Deny.
And Chair Costa.
Approve.
So that is a 4-2.
4-2 vote. So it stands?
Yes, yes. So
Stands as a denial?
Yes, it's a denial of that particular variance.
They have an option to appeal?
Yes.
Okay.
And they would have to redo the site plan because, obviously the proposed house is too big. So within the constraints that you approve, they would have to come back with a site plan for the fence height and the setback provisions, but they have to keep within that 35% lot coverage.
Okay, all right, thank you. Got that applicant out there? All good? Thank you. All right, moving on to the next case then. And Ms. Shelley, we are skipping the CPA and the PUD, so we're going to Z.
Got it. Case number Z-26-029, rezoning from the prime agriculture A1 zoning classification to the rural agriculture A2 zoning classification.
All right, and this is Miss Ray again.
So the applicant is requesting to rezone a 5.44 acre parcel from prime agriculture A1 to rural agriculture A2. The property is approximately 340 feet north of incorporated city of Deltona and is currently undeveloped. The property was subdivided from a larger parcel in May of 1982. The property met the minimum lot area requirement of the A1 at the time of creation, which was 5 acres with no minimum lot width. In 1984, the minimum lot area increased from 5 acres to the current 10 acres. The immediate surrounding parcels are all zoned A1. Lot sizes of these parcels vary from 1 acre to 10 acres in size. Southeast of the property are 2 parcels that are zoned rural residential RR that have 1 acre lot requirement. Development pattern in the area is transitioning from larger 10 acre lots to more smaller lots of 5 acres or less. The property has a rural future land use designation, and A1 and A2 zoning classifications are soon compatible. Applicant's intent is to utilize the less intensive minimum yard requirements to construct a single-family residence. The subject property is a corner lot, and the 2 front yards have a 30-foot ingress-egress easement that is located on the subject property. The minimum yard requirements would be measured from that easement line, as you can see on the picture in front of you. When the A1 minimum yard requirements are added at 100 feet for the front yard and 50 feet for the side yard, it decreases the buildable area. The A2 has a front yard requirement of 50 feet and a side yard requirement of 25 feet, giving them a greater buildable area. Both the A1 and A2 zoning classifications would allow just 1 dwelling unit on the property. Staff recommends forwarding the rezoning application to County Council for final action with a recommendation of approval. I'm available for questions.
And I believe, Ms. Craig, you have a question? No? Ms. Bush, go right ahead.
Thank you. I'm just curious. We get, I understand. I don't understand. This gentleman is rezoning this property in order to build it because of how just erroneous and strict these A1 setbacks are. If the Chairman Mills were here, he would echo this as well. I just out of curiosity, and you don't have to answer this now, maybe this is something that Samantha and you all can do research on. How many A1 zone properties are non-conforming? Because we get a lot of requests to build on these properties, so I'm just curious, is it time to reevaluate that?
We do not have that number. That would definitely be a research project.
Okay.
Staff to
Just
evaluate and look at it.
Yeah, just out of curiosity, because we get a lot of the requests to develop these, and a lot of them are substandard. Like, they're not substandard, but they're not the 10-acre minimum. So maybe that would be worthwhile to maybe come up with some kind of policy that then would allow these individuals that are going through this process to do so quicker, right? Thank you.
Absolutely.
Any other questions for staff? Nope, thank you. Is the applicant present? Would you please come up, state your name and address for the record?
David Cole, 2870 Appaloosa Trail, Deltona, Florida.
All right, you've heard the staff report. Anything you would like to add?
No, sir. I really don't know what to say. I've never done this before.
Okay. All righty then. Have a seat, and if we need you. Actually, hang on. Anybody have any questions for the applicant? You may have a seat then. Thank you. Any public participation on this case?
No, sir.
None. All right. In that case, we close the floor, and let's open it for discussion and or a motion.
I'd be happy to make a motion.
Please do.
Z26029, forward rezoning application to County Council for final action and recommendation of approval.
Second.
We got a second by Ms. Shelley over here, and any discussion on the motion? Anyone? No? In that case, all in favor, signal by saying aye.
Aye.
All opposed? Motion passes unanimously. And the next case, please.
So going back to...
We're going to do the ordinance. Go ahead and do the ordinance. We'll finish it up.
do the ordinance. Case number O-25-008, ordinance 2026-009, 05, amending Chapter 72 of the Code of Ordinances to amend zoning classification and backyard chicken regulations.
Ms. Ray, take it away.
Alrighty. So in May of 2025, the County Council meeting, Council directed staff to review the regulations for backyard chickens in urban areas and consider reducing the minimum lot size requirement. In January of 2026, Council discussed staff's findings and directed staff to prepare an amendment to the backyard chicken regulations to eliminate the lot size requirement, eliminate the need for a conditional use permit, allow for chickens to be either fenced or within a coop, and to raise the maximum number of chickens allowed per lot. Currently, backyard chickens are permitted through a conditional use permit within the following zoning classifications: urban single-family residential R1 through R4, urban two-family residential R6, and urban mobile home subdivision MH6. The minimum lot size for backyard chickens is 1/4 acre or 10,890 square feet. The R3, R4, R6, and MH6 zoning classifications have a minimum lot size requirement that is less than the 1/4 acre, resulting in the conforming lots within these zonings cannot meet the minimum lot size for the backyard chickens and are unable to keep chickens. Section 72-293-5 establishes 11 standards for our backyard chickens within urban areas. A couple of these standards are no more than 5 chickens or hens. Chickens must be kept in a fully enclosed predator-proof coop and are not permitted to be free-range. Coops may not be taller than 8 feet, may not exceed a maximum of 150 square feet, must be sheltered or confined to prevent contact with wild ducks or geese, etc. Staff researched the urban backyard chicken regulations in 16 local municipalities and 7 adjacent counties. Seven out of the 16 municipalities regulate backyard chickens. Only 2 have a minimum lot size requirement. All 7 counties regulate backyard chickens, and none have a minimum lot size requirement. And the average maximum number of chickens permitted among the jurisdictions is 5. Based on council direction and comparative research, staff proposes to allow backyard chickens as a permitted use instead of a conditional use permit, eliminate the need for a building permit for the chicken coops, eliminate the requirement for a University of Florida Agricultural Extension Service class completion, eliminate minimum lot size requirement, and establish a sliding scale for the maximum number of chickens based on lot size. Staff recommends finding ordinance 2026-05 consistent with the comprehensive plan and forwarding it to County Council for final action with a recommendation of approval. I'm available for questions.
And I've got a few of them for you. I'll let Ms. Bush go ahead, please.
Okay. I had sent you all my questions ahead of time, right? So
Yes, ma'am.
I will just ask them now for the public and for everyone else to hear. My first question, first off, I want to commend the research that you did. It was very thorough. The way that you put that together, it was easy to read and comprehend and understand the flow of information, right? And how the logic model, how you were able to decide what it is that you were going to remove and or keep within the modification of your ordinance. So excellent job on that and walking me through that process, right? It was like, I was in your head. I could get it. I just had a few things where I was like, okay, I don't understand that, right? The minimum number of chickens. So less than 5,000 square feet. And I pose this again, do we know how many lots we have that are in that category?
So I was unable to do that type of research because it would take our mapping team. Yeah. So unfortunately, I was not able to get that number for you. However, it was a maximum number of chickens, not a minimum. So I don't know if that's... So it'd be a maximum of 3 for those.
I just was curious on the 3 number because in the research, everything was 4 and up. And typically you try to think of like a chicken per person. So if you had a 4-bedroom house on a 5,000 square foot lot, you'd want 4 chickens.
Right. So kind of how I worked it is, so the average is 5. And so for the 5 chickens, you'll see that sorry, let me get to the table. That it's 75,000 square feet to the 9,999 square feet. Our most common urban zoning is R4 that has that minimum lot size of 7,500 square feet. So with the average of 5. And then as I went down, I just kind of Minus the chicken.
Understood. That was just something that I would consider is not necessarily
Right.
the sliding scale based on the square footage, but maybe by the occupants that the chicken is
Okay.
trying to feed. Because that is the purpose, right? I mean, at least that's why I have chickens. I don't carry them just to have them as a backyard animal. They're providing eggs and subsistence for me.
Right.
My second question, you struck through no more than one coop shall be allowed per permitted parcel, which I understand because we're not obviously permitting those, but I would keep the one coop per parcel requirement so that if somebody has 3 chickens and they all have 3 coops, that might get a little stinky, noisy, it might get excessive, and you would have no way for code enforcement to enforce that. They also might be moving coops because they don't want to clean the coop, which is another one of your requirements. So something to consider.
Right. That one was struck because the 1 acre or more of the 20, we want to be able to, if they wanted 10 and 10, they would have the option to have those 2 coops.
Got it. Maybe then there's a clause in there that could stipulate if it's residential properties under a certain square footage, then they're only allowed 1 coop, and if you have a greater square footage, then more than 1, because that would be appropriate for the size of the lot. My next one, and this one I'm not sure how you're enforcing this now, so please, I would love to know. The fly-tight bin must be kept at least 20 feet away. This is where you put the poo, the manure. It must be kept 20 feet away from all property lines. I'm just curious if that's feasible for a property that's 5,000 square foot or less.
So that was a part of the original adoption. And of course, the intent is to keep it away from all property lines so it doesn't, of course, this odor. That is subject to change if the commission wants to propose something. If they want to do it for accessory structure setbacks, of course, for the smaller lots, that's up to the commission discretion.
How is that being maintained? Is it being
Code
enforced?
enforcement.
And have there been any issues with this on residential properties that are half an acre?
The main code enforcement that we've seen is based on roosters, not so much the fly type.
Okay.
bin.
I just was curious on how
Absolutely.
enforceable this was.
It's our code enforcement. So once they get a complaint about it, then they go out and investigate.
I can just see this being one of those issues that neighbors fight each other about and argue over the specifics of it, and I just am not sure whether or not that's really pertinent to 3 chickens,
Absolutely.
right, at a minimum. So those are my questions. Thank you.
Anybody else? Ms. Craig?
Yes, thank you. Looking through the attachments from the various other towns, and I see that a number of them mentioned owner-occupied dwelling as being a restriction. And I was wondering if there was a reason for not including that in what we're putting forth.
I'm not sure. These are for backyard chickens, so for our urban areas. So a lot of times it would be for their residents, for them to have backyard chickens. So it would be owner occupied.
My question is based on the fact, or my understanding at least, that an owner-occupied property like this, the owner of the chickens is going to be more likely to be careful about it and take it rather than a tenant. So that would be my suggestion, is to add that as one of the conditions.
If I might, Assistant County Attorney Chris Ryan, we just have to remember that we're still under the ambit of SB 180, so any restriction that's more burdensome is something that would not be allowed by the ordinance.
And also, I believe this accommodates for rental properties.
Yes.
Someone wants to rent a house and have chickens. If you have owner-occupied restriction, we would not be able to allow a renter who rents a house to have backyard chickens.
So the towns that currently have owner-occupied restrictions to it, will they not be able to enforce that after SB 180?
No. It's SB 180 is you can't be more restrictive. So you can keep what you have, you just can't make it more onerous.
Anyone else? I've got a couple questions for you. So on the acre or larger, there is no maximum?
It's no greater than 20.
No greater than 20? for
1 acre or more.
more 1 acre or more. So if you got a 5-acre parcel, you're limited to 20 birds.
Yep. This is just within urban areas.
Within urban areas only?
Yes.
Okay. Again, if you got a 5-acre parcel inside of an urban area,
It's rare, but there's some urban properties that are large.
mm-hmm. That's that one here. I would have another lot size classification on there. I would probably go at 2.5 and above is probably an unlimited source. That's my opinion. So
Absolutely.
I'm just going with the intent of what the council kicked it back to us, that they're basically looking at less restriction on this. And then the other one that I had was regarding the coop size. So 150 is across the board. That's your maximum size coop, whether it's on a 5,000 square foot lot or a 1 acre lot.
Yes, sir.
You can have more than one coop.
I was going to say, you're going to be hard pressed getting 20 birds in 150 square feet.
Right, and that's why we struck the
Okay. Got it.
limited to 1.
Aesthetically, though, multiple 150 square foot coops versus one 500 square foot coop. From a maintenance standpoint, a cleanliness standpoint, one-stop shopping versus having to now spread it out that's something I think we might want to fine-tune it just a bit.
Okay.
Instead of the one shoe fits all size. And that's it. That's all I had. Anybody else? Go ahead.
Oh, I just wanted to comment on that question
I'll come
on
right
the
back
urban.
to you, Ms. Craig. Sorry.
Oh,
No, go ahead.
okay. You said it was for urban areas only. I was assuming that was residential. So
Yep, urban residential. So those the zoning classifications I mentioned earlier, it would just stay within those zoning classifications.
Okay. So anything ag is not.
No, those are by right, and we don't regulate any.
Yeah. Okay. That's how you defined urban. I just
Yes,
wanted to
ma'am.
confirm.
Ms. Craig, did you have something? No? Okay. Anyone else? Do we have any public participation on this?
No, sir.
We don't?
Oh.
If you'd like to come up and speak, yes, afterwards, please fill out a form in the back of the room and turn it into to Ms. Tucker. Oh, chicken discussions?
Yeah.
It's about about the ordinance, not about chicken raising, right?
No, I'm just saying because you were having about talking about 3 to 4 and stuff like that per household and stuff like that. They usually working in the pet industry. Usually they sell 4 to 6 usually because they want to make sure they survive and make sure they have the proper heating and stuff like that. Now with the stuff going on now with freeze, they will want to keep the higher amount, not 3. 3, they're more likely to pass away and die. And another thing about the fly thing about their poop. There's also seen online stuff. A lot of people with smaller areas like this, they also like to put them on wheels. So they actually could move them, and they're actually more cleansy. You were saying about being clean. So actually, if they move them, keep moving the coop, it can actually keep it the waste down, it'll keep the smell down, it will keep it more hygienic, and it will be more approval for a thing. This may be a suggestion for you guys to do for people that have smaller lots and stuff like that. So they could be more, so they could be able to do it instead of being a problem.
And can I get you to state your name and address for the record?
My name is Antonio Jimenez Goron. I live at 2680 Palm Drive.
And do you have chickens?
I used to have chickens, yes.
Okay.
And I'm planning to try to have some chickens again.
Okay, great. Congratulations. Thank you. Thank you for your input. Please fill out the form at the back of the room. Thanks. Any other public participation? Anybody else wants to discuss chickens before we move on? No? All right.
I have a comment.
Go ahead.
I grew up with backyard chickens, and I loved getting the fresh eggs in the morning, so I'm glad we're doing this.
Mr. Chair, if I would recommend that if you would want to make changes to the ordinance, you do so in the form of a motion to change specifically the language so that we can bring it to council with those recommended changes.
That would require me to go back here and rewrite this, huh? Are we ready to do that?
You have a list? Yeah.
Well, let's go through that. Who else has? What other issues do we have besides mine? And let's do it that way before we even start making a motion on here. Go ahead. Give those to me one more time.
Okay, so I had an issue with the maximum number of chickens being 3 for lot size less than 5,000 square feet. I also had an issue with there being removing the no more than 1 coop. I wanted to keep the 1 coop requirement. However, I recognize your comment, Chairman, so I would be willing to suggest maybe what we need to do is have staff go back and evaluate
Yeah.
the square footage of the coop size and
Have a
bring
s-
that back to
I would
us.
agree. I would agree with you that we should have a scale for that. The
Yeah.
Same scale for property size versus number of coops or coop size.
And the number of chickens, because that is absolutely,
Yep.
you can't have one without the other.
Mhm.
And then the whole fly type bin, I don't know if that's really necessary if I'm making a mountain out of a molehill, but if it's something that we are putting into a policy that we have intent to enforce, it should be enforceable for all intents and purposes. So maybe there's another way we can look at writing that. But those are my issues with it.
Okay.
I do agree also with your comments, Chairman, and I do think that there needs to be a breakup of the 1 acre and 1 acre more to the
Yep.
half acre. Yeah. So I think this needs some more work,
Yep.
and I would be willing to make a motion to table this
What I want to do.
in
That's
order
exactly
for
what I wanna
staff to bring back the recommended changes we are suggesting.
Is that a motion?
It is, yes.
I'll second.
Oh, I'll second that, yeah.
All right. Before we go any further, so Ms. Bush, that was you. Mr. Arison, you have something else to comment?
That was going to be my motion.
Okay,
to- yeah.
so let's go that again. So we have a motion on case 025008 by Ms. Bush and a second by
Mr. Urson.
All right. That motion is to table this for some additional research and corrections and bring back to us.
For the
I
comments.
Yeah.
For the
believe that
comments,
you're-
30 days, 60 days? How much time do you need?
Yes.
Um,
30 days?
I'm looking both directions.
Do we think the May meeting?
Yeah, I think May PLDRC is the earliest we could do.
We have a little more space there
Yes,
on May?
please.
Okay. All right, so we'll table this to the May exact date.
21st.
Thank you.
I'll amend the motion to read that way.
Yes.
Okay,
I will
go ahead.
I will amend that as well. Do you want me to amend it?
Yes, please.
I move that we table ordinance 25-008 to the May 21st meeting.
Yes.
And Member Urson second.
All right, so a motion to table case O-25008. Motion by Ms. Bush, second by Mr. Urson, to table it to the May 21st meeting for staff to revise and/or incorporate our comments. All those in favor, signal by saying aye. Aye. All opposed? All right, ayes have it. See you in May. And that brings us back to the CPA and PUD, please.
Oh, we've got the stipend discussion.
Yeah, we'll do the stipend at the very end. He's here, correct?
No.
Not back yet?
Okay, yep, gotcha. Okay, I didn't turn a page. Okay, CPA, okay.
Apologies. Just to clear up any confusion, I'm not Mark Watts, but my name is
Understand.
Kelsey Hansen, and I'm filling in for Mark Watts for this one.
Okay, so is he
you guys
coming
will-
back or you're going to take over?
I'll take over for
Okay,
him.
got it.
Ready? Okay. Case number CPA-25-006. Small-scale comprehensive plan amendment from the urban low-intensity future land use designation to the commercial future land use designation.
And the accompanying one, please.
Yes. Case number PUD-25-005, rezoning from the general commercial B4 and transitional agriculture A3 zoning classifications to a planned unit development and a business subclassification.
Okay, this is Ms. West.
Okay, good morning.
Morning.
So we have two cases before you today. One is the land use change from urban low intensity to commercial, and the other is the rezoning from B4 general commercial and A3 transitional agricultural to PUD with the business subclassification. This is for a site located at 1971 Old New York Avenue in DeLand on the northwest corner of South Ridgewood Avenue and Old New York Avenue. So this is really to have the existing Stockyard restaurant, DeLand Stockyard, to bring that into compliance with the current code. And then also, and that's on the east side of the property. And then the west side of the property is a proposed event center. The restaurant itself was built in the 1930s and has continued as that use throughout time. The house, which is in the center of the property, was constructed in the 1950s, and the barn was constructed in the 1980s. The owner of the stockyard purchased those 2 additional properties to the west between 2021 and 2023, and anticipated this event center use on the property. What we're doing today for the land use amendment is that through the PUD, we're going to be limiting the limiting the intensity through the PUD at 1,000 or 12,500 gross leasable area, which is about a 12% FAR. And that is going to make the commercial is going to be limiting that use, right? So you can't come in and put a brand new commercial use into that property. So we're going to be conditioning the land use change upon the approval of that PUD. Other things that are going on the site is that there's 70 spaces on site for parking. And across the street, they have an overflow parking area with an agreement to the south at the Magnolia Christian School. The site itself, for additional landscaping and what have you, so they're going to have used the existing landscaping on the north buffer adjacent to the railroad, the existing landscaping on South Ridgewood Avenue that is surrounding the existing restaurant. The new landscaping that they're going to be putting in is in the low impact retention area. As you can see, it's an existing constrained site. This is a redevelopment, right? They are utilizing the current barn, the current barn as the event center itself, the single family dwelling as the bridal suite, and the restaurant will retain that use. So changes to the site is really going to be the additional parking on the eastern portion, the additional landscaping in the low impact retention area. They're going to be adding retention to the site, which didn't have it before because it was residential uses and an historic site for the restaurant. So bringing things into compliance, we are making it to where we have uses that have been going on in our community for a very long time, making that into compliance as well. And also putting safety improvements across Old New York Avenue. As you can see where it says DeLand Junction, we'll have an area there for the crossing to that overflow parking, which is definitely needed in that area. If you have any additional questions, I am here.
Yeah, we have several. I'm going to start first, if you don't mind here. This is all triggered by what, the addition of the event center?
Yep.
Is that right?
Yes.
That what started this whole
Yes.
ball rolling? Okay. All right, Mr. Erickson? I want to keep putting an IR
that was
in
from
there.
before. Sorry, we need to reset.
You're done? You don't need, okay, Ms. Bush?
Thank you. Curious, what's the speed limit on Old New York Avenue?
Full 35. 35?
30.
This is my neck of the woods.
Okay, so
I think it's 35, 40.
35? Okay. I was just curious. The crossing, I was just curious at what the recommendation there for that, whether or not that was going to be an activated crossing or passive crossing.
I believe, you mean activated as in they're going to have the flashing? I believe they're going to have that there.
Okay.
Yes.
Good.
And there's one thing that I forgot to mention, which is a large portion of this, is in the center of the property, about where you see, I can't do this line, right here, this area. Forget that one. There is a hiatus between the two plats that are located there. So the attorney for this property is looking into who the ownership of that hiatus is. It's about 30 feet, if I'm not mistaken. It might be a little bit less. So the recommendation from staff is a recommendation of approval subject to, delete that for you, subject to resolution of the ownership of that hiatus. If that makes sense.
All right. Any other questions for staff? Is the applicant present?
Hi, good morning. Once again, not Mark Watts, Kelsey Hansen, 231 North Woodland, Cobb Cole. I first just want to thank staff. This is one of the first projects I got to work on with county staff and Mark, and it's been very enjoyable. Big learning curve. Second, we received the responses from a neighbor. I believe Ms. Moon had sent an email to staff just before this commission. As I understand it, we do have a 15 to 20 year colorful history with her. And I believe the PD, the language in the PD does address her main concerns regarding noise and traffic. Specifically, as you asked about the crosswalk, yes, we're going to install the crosswalk for safety purposes with the flashing lights, as we have a separate agreement with the school for overflow parking. And then the noise, the language in the PD actually provides for stricter standards regarding noise as to the event center. So I believe any qualms that Ms. Moon may have are addressed in the PD. And as Ms. West mentioned, we're here to just request that the appropriate land use and zoning be put in place for this existing site, and it's been around for a very long time as the restaurant and now the event center. So, we worked with staff on the PD agreement. Specifics in the agreement include the noise ordinance, which, like I said, are a stricter standard. It won't go past 11 p.m. And we're not requesting any deviations from the county's noise requirements within the PD. The parking, as I mentioned, will provide additional parking requirements and accommodations and safety features with the road improvements. And then restrictions as well as to events. We did have a conversation with staff regarding restrictions during weekdays until a traffic memo is approved by the county. And then, so the event center will not hold events on the weekdays and then have limited hours on the weekends. Other than that, we're here for any questions you guys may have regarding the project, but it was a enjoyable one, as it was my first time transitioning from litigation to land use. So here for any questions.
All right, Ms. Bush.
Sorry. Are you planning any lighting improvements along Old New York Avenue with this proposal?
We are not, besides the crosswalk with the lighting structure to avoid any sort of serious hazards along the 35 mile per hour. Nothing that we're aware of.
The intent, I'm assuming, to use the overflow parking is in the evening hours when the restaurant is busy?
Yes, and also for the event center on the weekends.
Okay. I would just be concerned about lighting because of the fact that most fatalities and serious injuries to pedestrians are at night or in dusk or dim lit hours. So having a rapid flashing beacon at this location is fantastic. However, it only goes so far if that is not lit. Because this is an area that people are going to be traversing that facility, I would highly recommend that you add some sort of lighting. If it's not roadway lighting, that you, as the representative of this business, do lighting in order to ensure that there is visibility for the safety of those patrons crossing that road. The event center I'm not as concerned with because that's a daytime activity, but I am always very concerned about people crossing any type of roadway at night that's not lit.
Understood.
I do this for a living, so.
Understood. And
it might not be in your PUD, it might not be in the DA, right? But I'm just for you all doing your due diligence and making sure that your patrons are protected.
Yeah, I believe the lighting language in the PD refers to just night sky standards, but we can discuss any additional lighting along New York Avenue if it's required. I believe I'd have to bring it up on Google View if there is any sort of posts or anything outside of the restaurant, but as to the event center,
Yes, there is. We're looking at aerials right now.
Okay.
There is one right across the street for where that crossing is about to go, right in that general area.
Oh, perfect.
And yeah, on the other side of the street where the Magnolia Christian School is, and the stockyard itself also has, not really pedestrian scale, but close enough lighting along the front.
Okay.
as well.
I would just do your homework, due diligence, and review what that looks like at night for for patrons that are crossing.
Makes sense.
Thank you for putting that in.
Any other questions? Thank you.
Yep. Thank you, guys.
Do we have any public participation?
No, sir.
All right, other than the letters of the two emails that we have, correct, from the same person?
Correct, yes, sir. The
All
two
right.
letters you were provided this morning.
All right, in that case, we will close the floor for public participation and bring it up to us for either a motion or discussion, or both.
I'm happy to make the motion.
Go, sir.
My neck of the woods there. Okay, CPA 25006, motion to find a future land use amendment consistent with the comprehensive plan and forward the application to County Council with recommendation of approval to transmit to the Florida Department of Commerce for expedited state review and the Volusia Growth Management Commission.
Second.
All right, I have a motion on the floor made by Mr. Erson and seconded by Ms. Shelley, and it's on case CPA-25-006 to forward to the County Council with a recommendation of approval to transmit to the Florida Department of Commerce for expedited review.
Yes, with the two conditions.
I'm sorry?
There's two conditions.
And there's two
I
conditions
second
on
the
here?
two conditions, yes.
And that is amended with the two staff recommended conditions. All those in favor?
Aye.
Aye. All those opposed? So CPA 25006 passes unanimously. And then we'll also do the accompanying case, which is PUD-25-005. Can I get a motion on that?
Okay, make a motion for PUD 25-005 forward the rezoning application to County Council for final action with recommendation of approval subject to the attached master plan consisting of proposed written development agreement and the preliminary plan of the two conditions.
Second.
So I have a motion from Mr. Harrison and a second from Ms. Shelley on case PUD-25-005 to forward to the County Council for final action with a recommendation of approval with the two staff recommended conditions. All those in favor, say by aye.
Aye.
All those opposed? This motion passes as well unanimously. All right. That brings us to the PLDRC stipend discussion. And anybody presenting this, or we're just on our own?
I'm here.
I'd like to make a comment.
Go ahead. Yes, go ahead, please.
I'm going to have to leave at this point because I have to be somewhere. So I will not be here for the discussion.
Okay.
Thank you.
We're going to miss you.
I'm sure you will.
Thank you. All right.
Before you leave, though, do you have any comments on topic?
Yes, the same ones that I've had before. I've never had a stipend, so I'm fine with what we have or whatever the board decides. That's here. So.
Thank you. Okay.
All right, so this is a discussion to increase the monthly stipend for the Planning and Land Development Regulation Commission members. I provided a brief timeline of what we have spoken about today, or previously. So back in November of this past year, you asked staff to do some research, which we provided, which was about adjacent jurisdictions, mileage reimbursement rates, and package printing costs. Back in December, you provided general concurrence to table discussion until March, which is when we are in the middle of budget right now. And then last meeting you voted to add the item to this agenda. So the current rate is $200 per meeting, which was allocated via resolution in 1987, an expense allowance to be paid to each member. Just a brief history about the other boards we have. The Code Enforcement Board is the only other advisory board whose members receive a stipend, which is set at $100 per meeting attended, which is a little bit different than ours. The majority of the cities do not provide a stipend for their planning commissions. There is a travel per diem in Putnam County at $30 per site visited. And the mileage reimbursement rates were updated from the last research that was done. And it is 72 cents per mile for the federal government. The state is 44 cents per mile, and the county is the same as the federal government. Our average printing per month is $159.93. And staff's recommendation we just give you a couple options of what you would like to do. One is no action, and the other is we add a discussion item for county council to increase the monthly stipend to whatever amount this commission desires.
Any questions for staff? Any discussion amongst ourselves? Yes, go ahead, please.
Member Craig, your mic's not on.
Sorry.
Thank you.
The printing and mailing cost, is that for the whole board, or is that per person?
That is the cost per meeting.
Per meeting, okay, thank you.
That's changing here soon anyway. Post office.
How many people get a paper copy? I mean, I've always loved the paper copy so I can make my notes and stuff. I mean, I get one. Yeah,
So
okay.
6 out of our 7 members of our board have now
so
opted
good. You're
for
so good.
paper copies.
Yeah. Okay. My thoughts are, I know the cost of traveling is up and down, especially with fuel costs, but it also goes back down. I would say no action on my part. That's just my thoughts.
Does anyone put any motion or anything? It's just an informal discussion and count.
I would recommend having a motion.
Yeah,
since
I'm
it is
prepared
the-
to make one after.
Go right ahead. All right, anybody else have any other comments? Ms. Craig, this is an old one?
That's an old one,
All
sorry.
right, okay. Yeah, go right ahead, make a motion.
I move forward with a motion of no action.
Second.
Second.
Okay, that's fine.
You got it.
All right, so we have a motion of no action on the PLDRC stipend made by Mr. Erson and seconded by Mr. Sixma. All in favor, say aye.
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 All opposed? Aye. That would be 4-1.
Okay.
So it dies right here, correct? Correct. All right, we're done with that one. Yeah, now that I lost my help, my assistant, I'm kind of lost. Here we go. Okay, do we have any other public items?
No, sir.
Do we have any staff comments?
No, sir.
Any commission comments?
I commend you for your good job today.
I appreciate it. Feel like I was stumbling over myself, but all right, thank
Right,
you.
you still did a good job.
Any other staff comments?
Yes, I do have one. I don't know if it's a form of emotion, but it is that time of year where we have to reset the absences. So let the record reflect we're starting new. This is year 2 now. And with the new policy we passed that allowed 3.
Mr. Erson, that is
Correct.
still, that is not in effect because I have to draft an ordinance because it's in our ordinance. So we still need to go to county council for
Okay.
them to approve those changes.
So we'll
but
hit that up.
yeah, but you are
try.
correct that, and we have a new time period because the time period started in January instead of March. So everyone reset in January. This is per calendar year.
Okay, we're doing per cal. We had that discussed. I thought it was April.
But we're changing it to April because it makes sense for the reappointment.
So it'd be appropriate for me to do that once this is done, right? I get it.
Yes.
I
yes.
gotta wait. Okay.
I mean, everyone has been reset since January.
What's the timeline on that ordinance?
Assuming that nothing gets weird and I can find
You being weirder?
find something on county council, maybe June, because I'll try for May, but hopefully for June. But it may be like June-ish.
All right, good enough. Any other commission comments? Any press and citizen comments? All you folks in the blue shirt, that's twice in a row. Nobody wants to talk? I mean, I'd love to hear from you while you're here. No? Okay.
You're scaring us.
All right, hearing nothing further, then we're going to call this meeting adjourned.
Great job. Yeah. Okay.
Yeah, these past couple days. Maybe this is the last one. I don't know. I like the cooler though.
It's cooler too outside than inside. I wish they would do something about that.
Take care.
Yeah. Hi, yeah.
Didn't say. He
Thank you. I appreciate that.
Doctor appointment,
And thank you for attending. suites before you go? They're at the other. They're in the other one. Okay, that was where I was headed next.
Sliding scale. I think it was 3. Started very 3.
I watched it online. I was like, oh, it's so good.
Well, you know, that's the whole chicken ordinance came up during COVID. It started actually. People started popping them up. I think it was before that, but that was the proliferation of it. So she's got on here. Well, you know, there's 40 wide lots, right? Which would be, I think they're limited to 53. Oh, oh, I know. There's no space. There's no yard space there. So yeah, we started maximum number 3 if you're less than 5,000 square feet. Actually, we have that page. I got 20. So I might be my problem is that we have some this area. Right. So you're going to limit them to. I have 5 acres. I have 4 birds on my west. And it's more than enough. They can be my model free range of 5 acres. They free range, come back and sleep at night. But I couldn't imagine being limited to 20 birds on 5 acres. It's just, you know, the flip side of that was what this discussion we had was they were calling out for having fun. You could have multiple scooters, but why would you want to have all these different structures when the chickens are pack animals? They're all going to want to be in one big thing. But no roosters is always going to have a backyard. Yeah, here's the thing about that. Some people don't understand. When you sexing a chicken is not a science. Sexing a chicken is actually it's an art form. So when you go say you go to Tractor Supply and they say, hey, we got they're selling chickens or whatever, they tell you they're sexed. Means that there's a 99% chance that they're all females. There's that one rooster that got by the chickens out of town. Very likely you're going to end up with 1 if not 2 roosters out of that much because it's not an exact science when they're sexing birds. So sometimes you don't know until they're now yay tall, which is going to create a home battle. Cabbage patch is the perfect place. That's where everybody goes to dump the roosters. You go to the cabbage patch and there's nothing but there's roosters all over the place. How they get along, they don't know. Yep, they just go and just dump the bar that's out there and they just hang out there and they live out their life and that's where people dump them off. Which is, you know, again, there's no need to go through the added expense and go through the survey. Just for a couple chickens. The sizes they're talking about, I don't see that. Yes, they do. Yep. You can go to Tractor Supply and get a chicken coop, you can get the chickens, you can get the feed, you can get everything you need right there. And probably buy stuff you don't need. Except for pig, yeah. Yeah, I'm out of the pig business. I've been out of the pig business. Do I get eggs? Oh, no, they don't sell them at Tractor Supply, but no. You buy those online though, all day long. All right. Well, you have a great day. Oh, no, we had, what, 2 weeks of summer, and all of a sudden, this nonsense hit. I just trimmed back all my mangoes and avocado trees yesterday for the first time right after the cold. And I'll end up probably going to lose 2 more trees from the freeze. I mean, they were too big to cover. Right flush to the ground, the puffs will come right up. I did that to mine as well. I have a whole cluster of bananas. They were this color. Yeah, I cut them flush to the ground. I know. It is. It's a lot of work, and unfortunately, They say it's here. I haven't seen it yet.
Yeah, they're already back. I gave him the 2 for stockyard and the